If you've been employed for 2 years or more, you have the right not to be unfairly dismissed. There are various potentially fair reasons for dismissal, which include redundancy, misconduct, capability, performance, and an employer has to have one of those potentially fair reasons to dismiss in order to fairly dismiss, and they need to follow a fair procedure in all the circumstances in order for the dismissal to be fair. If you feel that your employer doesn't have a potentially fair reason for dismissal or hasn't followed a fair process and they dismiss you, the first thing you should consider doing is appealing against the decision to dismiss. Your employer should give you the right to appeal, and they should also follow the ACAS Code of Practice on discipline and grievance procedures, and also any disciplinary procedure they may have internally, which is usually found in the staff handbook. And where that's not been successful, we can assist in negotiating an early settlement, which could protect your financial situation or your career and reputation. And if that's not possible, as a last resort, you may want to consider bringing employment tribunal proceedings, and we can assist you with that. In terms of taking advice, it can generally be very helpful to take early advice either from your trade union representative or an employment solicitor on how best to put your case, how to robustly defend any allegations that are levelled against you in order to protect your career and your reputation. And clearly, if the decision is made to dismiss, that can be catastrophic for an individual. Employment law can be quite complicated, it can be difficult to navigate, and if you're in the situation in which you feel you're being unfairly treated or discriminated against, or that you've blown the whistle and you're being treated detrimentally as a result, we can assist you in advising you on what your legal rights are and in helping you navigate through what can be a very difficult situation.